Hello, everyone, and welcome to One Civil Law, where, as always, we learn through the misfortunes of others. As always, I'm your host on Civil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a great day. For today's story, we turn our attention to Las Vegas, where a defendant, who apparently has been let go by the system over and over again, despite multiple felonies, multiple misdemeanors, multiple domestic violence incidences, robberies, assaults, batteries, finally, it seems, is going to get some prison time, at least according to this judge. So Las Vegas has lost its patience, but the defendant apparently was unwilling to accept this culmination of his own criminal misdeeds. If this had been his first offense, I'm sure that he would have been let go with a much more minor penalty, but it's in no way his first misstep. So he apparently has not had the pleasure of jail before, or not much of it, and so he decides to attack the judge. How fun and exciting. So we're going to watch this hearing take place where the defendant attacks the judge, and I have my earbuds in because the audio is very, very low. And also there's some noise in the background, so I'm going to relate to you what the people are saying because it's very hard to hear. So let's go ahead and get started with this. We turn our attention to the courtroom as it starts. We see, of course, a bailiff here in the middle with his attire on. We see the criminal defense lawyer in his blue attire there on the left. And we see the prosecutor there with his gray attire on the right. We also see a court reporter up there on the front in his suit. So that is how we start the scene. And of course, we have a little bit of a gallery here with some other people. Let's watch how this proceeds. This all happened yesterday in Las Vegas, about 24 hours ago.
3697.
So she just called the case. She called the case by number, the judge. And there's the defendant in the white. Now he comes up to stand at the defense table.
All right. This is time set for entry of judgment and position of sentence. Is there any legal cause or reason why judgment should not be pronounced against you at this time?
No, Judge.
By virtue of your plea of guilty, I hereby adjudge you guilty of attempt battery or substantial bodily harm.
All right, so now we're doing both a conviction and a sentencing, which, fair enough, right? Different trials happen in different orders in different ways. So we have an agreement. We have a plea agreement. This person has decided to plead guilty to attempted battery with severe bodily harm. So presumably he had a weapon of some kind or an instrument of some kind, or otherwise the facts were such that you can infer this attempted battery with this additional enhancement. But in either case, he pled guilty to it, okay? So she's like, okay, is there any reason we shouldn't do judgment and sentencing? No? Okay, I adjudicate you guilty, right, because of the plea deal. Let's see what happens next.
My notes indicate the state retained the right to argue through the bench warrant. Is that correct? Yep.
That is correct, Judge.
All right. State.
I think based on the criminal history, Judge, for listing the PSI, I know you see all this, I don't need to rehash everything. My concerns are there are crimes of violence.
Yep.
In the PSI.
So he said, based on the criminal history and the pre-sentencing report, both of which are very typical, of course, based on this, we have some concerns. I'm not going to go through them all, but there is a history of violence. Okay.
3 felonies, 1 probation revoked. But we do see on page 5 there are many probation violations. 3 mans on probation discharge.
So we have 3 felonies and multiple probation violations for previous probations. So that's what he says, right? We have a history. We have 3 felony convictions already, multiple probation violations.
But I have a concern based on the nature of criminal history, home invasions, battery, domestic violence.
Battery, domestic violence. I have concerns based on the history. Battery, domestic violence.
Assault with a deadly weapon in this case.
Assault with deadly weapon.
Substantial
I think he said in this case specifically.
Violence, assault with a deadly weapon in this case,
Yeah, assault with a deadly weapon in this case. So that would be the grievous bodily harm, right? He had a deadly weapon. What is the deadly weapon? I don't know. It doesn't really matter for the purposes of our exercise. Attempted battery with a deadly weapon. Yeah, that'll do it. For enhancement, sure.
an attempt battery is substantial. I think felony is appropriate, and I think a prison term would be appropriate.
Is there any restitution or victim impact?
So he says he thinks that a felony conviction here is appropriate, and he also says he thinks prison time would be appropriate. I think so too.
No judge, not the man today, so. But I do think prison is appropriate. I asked the court to impose 1948 on this case based on the criminal history and the facts of this case.
So I want prison time. He says 1948, which I'm not sure exactly what that means. A citation to some local code or something, but he thinks that's appropriate in this case. I do too. I'm not sure what 1948 is, but okay.
Mr. Redden, is there anything you want to say on your own behalf before I pronounce?
So now the judge asks for remarks from the defendant. Do you have anything to say on your own behalf? All right, let's see what the defendant has to say.
Sentence?
So basically, I would like to tell the courts, everyone here, like, based on my criminal history, like, I feel that, like, I shouldn't be, like, sent to prison for a second time.
He says, I just want to tell everyone here, based on my criminal history, I don't feel like I should be sent to prison for a second time. Okay.
Have you looked at your criminal history?
Judge says, have you looked at your criminal history? Yeah, based on my criminal history, I don't think I should be sent to prison for a second time. Have you looked at your criminal history?
Have you looked at your criminal history?
I actually just, I looked at it.
I mean, you lived it, I
I
suppose.
just looked at it.
He says, I looked at it. And the judge says, well, you lived it. Lol.
Yeah.
And, you know,
3 felonies, a gross, 9 misdemeanors, multiple DVs. Got a lot going on, sir.
3 felonies, gross, 9 misdemeanors, a handful of domestic violence. You got a lot going on. I think you do have a lot going on too. And that's his criminal history, by the way. We just added another one to that list just now because we just convicted him. So +1, make it 4 felonies.
yeah, I just figure, like,
Battery on a protected person, robberies.
Battery on a protected person can mean a bunch of different things depending on the locality. In the context of the fact it's domestic violence, I'm going to assume it means someone who there was a restraining order with respect to, that he assaulted someone who's a restraining order as a protected person, but it could also mean, depending on the jurisdiction, it could also mean someone elderly, infirm, a child, or otherwise not fully at full capacity. So, or it could mean, I guess theoretically, it could mean someone in the prison could be a protected person, or it could mean a lot of things. But yeah, someone who has some sort of additional protected status because of their status. So something like that, yeah, okay. Judge laying out some truths here.
Attempt home invasion.
Attempted home
Go
invasion.
ahead, I didn't mean to interrupt you. I was just...
The judge is like, have you looked at your criminal history? I'm not sure you have. Let me just remind you what your criminal history looks like. Since, you said earlier, based on my criminal history, I don't think I should go to jail. It's like, have you looked at it? Let me remind you. 3 felonies, 9 misdemeanors, domestic violence, batteries against protected persons. Yeah, it's not going great over here in your long life, sir. So yeah.
I just figure, like, I'm in a better place in my mind, in my mental health. I have a support system.
He says he's in a better place in his life and his mental health. Given what's about to occur in this, I'm not sure that he's in a better place with respect to his mental health. He says he has a support system. Does he, though? He says, I'm a changed man. How much of a changed man can you be, man? I mean, you keep committing all these felonies. Please stop doing that.
I just got hired as a teamster for, the union, making $20 an hour.
You got hired as a teacher? What?
My mental health, I have a support system. I just got hired as a teamster for.
Oh, a teamster. A teamster. I was about to have a panic. Woo! Okay, I got hired as a teamster for the union. Okay, I feel better now. Well, I mean, the Teamsters do have a bit of a reputation for strong arm tactics, so I can see why the Teamsters might like him. Lol.
The union, making $20 an hour, and like the reason behind every
$20 an hour is pretty good.
domestic violence, I've been dealing with mental health, and I didn't know that I was dealing with mental health. And they put me in mental health court, and I still didn't know that I had a mental health problem until it was August.
Wait a second. Wait. You said the domestic violence was due to your mental health, but you didn't know about it even though you were in a mental health court? Is that what you just said? Hold on. As we listen to his long rambling explanation, we need to make sure that we hear this all and get it right.
The reason behind every single domestic violence I've been doing, like the reason behind every single domestic violence, with mental health, and I didn't know that I was dealing with mental health.
Is mental health, and I didn't know I was dealing with mental health.
Mental health court, and I still didn't.
That's what he said.
Health, and I didn't know that I was dealing with mental health. And they put me in mental health court, and I still didn't know that I had a mental health problem.
They put me in mental health court, and I still didn't know I had a mental health problem. Okay.
Until it was August 2022 when I realized I have a problem with this. And
until August 2022 when I realized I had a problem with it.
I have an dictionary and understanding myself, getting to know myself a little better, and applying it to my personality, and having an epiphany at that moment in those instances, and just like trying to learn from my mistakes,
So I've been getting to know myself and learn about myself a little bit better.
I feel like I shouldn't be sent to prison, but if it's appropriate for you, then you have to do what you have to do. But
I feel like I shouldn't be sent to prison, but if it's appropriate for you, you have to do what you have to do. So he seems to acknowledge that the judge has the power. It's not like a surprise to him. He understands it's something the judge could do. It's like, I don't think I should do it, but if it's something you have to do, it's something you have to do. So, all right.
Figure that, if I'm in a better place in my life, I'm not doing drugs, I'm not out there committing crimes now.
I'm in a better place in my life. I'm not out there doing drugs. I'm not committing crimes now. Yeah. Well, I suppose in so much as now means literally right this second, you're not. Although in about 30 seconds, you're going to. So, yes, in so much as now means literally right now, I suppose you're not committing crimes. That won't be true for very long, though.
And I feel like I should be given a shot because I'm in a better place than I was then, so, but that's... I'm a person who never stops trying to do the right thing. No matter.
I'm in a better place now. I feel like I should be given a shot. I never stop trying to do the right thing. Sir, I mean, we've all made mistakes in our lives, including me, from time to time. We can all do it better. We're human. But I've never committed a crime. In my many mistakes in my life, so, and also I've not committed, 9 misdemeanors and 3 felonies. That's a lot. That's just, I'm just saying that's a lot. We all make mistakes from time to time, and we can all get to know ourselves better and improve. I always aim to improve myself. Sometimes I fail, but not so much with the massive criminal rap sheet, though. Okay.
How hard it is, and I just, and I'm trying, and I never give up trying to do the right thing. I know I'm not a rebellious person. I'm
not a rebellious person, he says. I'm not a rebellious person.
I don't want to be standing there. I want you to have to, sit up there and waste your time as well, you know? But the criteria of me saying this is that I'm a person that never stops trying to do the right things, even if it's hard.
I'm a person who never stops trying to do the right things. For a person who never stops trying to do the right things, you're about to fail very dramatically, very quickly. For a person who's reformed, for a person who has, seen the error of their ways, for a person who doesn't do drugs, for a person who has this great support system, for a person who never tries to stop doing the right thing, I can't help noticing in about, 10 seconds, you're going to fail once again. So I have somewhat disbelieving what you have to say on this.
I did the best I could. I have mental problems.
I have mental problems. Well, not for nothing, but I also have mental problems to some degree. But whether or not you have mental problems is not really the issue, because we've adjudicated you mentally able to stand trial. You know the difference between right and wrong. So sure, we all have mental health problems. I deal with depression, you deal with issues, but we're going to hold you responsible unless you're insane. You're not insane, you're clearly sane. You are making a lucid argument, although it is belied by your actions, but you're clearly sane. So yeah, you're mentally well in the sense of being able to help adjudicate. So, okay. So that's all he has to say. What happens next?
Mr. Almasi?
Judge, as
So after asking the client if he had anything to say, because of course he has the right to make an argument himself. So he asks the client if he wants to make a statement, and then asks the attorney. Fine. You could do it the other way around. Some judges do it the other way around. Ask for the attorney first and then the client. Either way is fine. So it's like, okay, do you want to say anything, attorney, on this issue?
The pre-sentence investigation report, my client was diagnosed with schizophrenia and bipolar disorder. And speaking with him, it certainly seems that he's following the pattern this court has seen some of the time. So self-medication.
So, based on the pre-sentencing report and based on my discussions with my client, it seems like he's fallen into the issue of self-medication, which this court has seen. I understand that. I have at times had to self-medicate because the medication I was on was ineffective and was self-medicating with alcohol, because, you're trying to find something to deal with something and nothing you're doing is working. But, you have to, so, fine. You can self-medicate, but it still doesn't allow you to get off on this thing, right? You're still responsible for your actions. You're responsible for, unless, irresistible compulsion, unable to understand the difference between right and wrong and all the rest of it. But he says, he seems to be doing okay. Okay, attorney, what else you got for us?
We've had 2 goes at mental health court, Mr. Almasi.
Okay, and the judge says, yeah, you've already had 2 goes at mental health court. We've already tried this twice. Right? So we gave you a shot at mental health court because of mental health. Then we gave you a second try at mental health court because we're just that compassionate. You've already had 2 goes. Yep.
He does have 2 honorable discharge from probation, so he can do probation. He can be successful.
He says, his lawyer says he has 2 honorable discharges from probation, so he can do probation. I assume he can. But unfortunately, as the prosecutor earlier pointed out, he has multiple probation violations as well. So in his long career of the 9 misdemeanors and 3 felonies, apparently, as to some of them, he was able to follow the terms of probation. So he's capable of doing it. He is capable, which means that the fact that he didn't is a pretty strong indication that he just doesn't want to. It's not a mental health problem. If it were a mental health problem, he wouldn't be able to comply, but he can comply. So yeah, he is capable, but unfortunately his record seems to indicate that he doesn't like to do that. So that's a problem.
It's true that he did get dishonorable discharge from both.
Someone asked, why isn't he in handcuffs? Because, for those of you who missed it, he was just adjudicated guilty at the very start of this hearing. So up to the start of this hearing, up till like 6 minutes ago, it's yeah, 6.5 minutes ago in time in this stream, or the master stream, not my personal stream, but 6.5 minutes ago, he wasn't guilty yet. So that's why he's in cuffs. That's why he's in street clothes, because he wasn't guilty yet. He's been adjudicated guilty, and now we're on to sentencing. So that's why we're having this argument. All right, let's press on.
And he was supervised for just very recently. But he is in a different position now. His foster mother, who is present as a show of support, is Karen Springer.
He's different now. His foster mother, who's here, is here as a show of support.
Has provided him a place to live, which is listed on the PSI. His current address at 8 Rose Circle, Apartment A, North Las Vegas. And she very graciously.
Yeah, fair enough. You've seen some courts where they handcuff guilty immediately, and some where they don't. Very fair. Yeah, you've definitely seen that where the moment the jury says guilty, they put him in handcuffs, and some where they don't. It's just a jurisdiction by jurisdiction thing. So fair enough.
Has allowed him to stay there rent free until he gets on his feet. Now, he is now part of Union 631 with Teamsters and is hoping to work his way through that program so that he can maintain work.
He's speaking,
There's
the
also
defense lawyer
recently
speaking about the Teamsters thing.
for, any job prospects that are available to him through them. Finally, Judge, it's not just his mental health that he's been contending with, but he also has a history of IEP in his education. And
Okay, so it's not just mental health, but he also has a IEP in his history, individual education plan. Right? So at some point in his school career, in his youth, he was not coming up to the standards, and he was under an individual plan because he wasn't behaving very well, even as a child.
Years old, he does not have a high school degree.
He doesn't have a high school
So we spoke
degree.
about that as well.
Yeah, he doesn't have a high school degree. Colored me shocked.
And I think it's high time that he did that. I think the court can trust him.
And he says it's high time that he do that, and he's just over here nodding. I mean, anytime you want to get your GED would be fine by me, man. You know where you can get your GED? In prison.
I think he's worth this risk. The court wants the 1948 as suggested by the DA. I would have no issue with that, but to suspend it rather than just send him to prison for.
So the defense lawyer agrees with 1948, which is whatever code number it is for the offense. So I suppose there was some disagreement relating to the plea or otherwise about what offense would be. So I don't know the exact contours of their plea, obviously. But the prosecutor said, okay, 1948, which I presume is a citation to some criminal code. Defense lawyer says, I agree with 1948, but I think, the sentence should be suspended rather than prison time. Okay, fair enough.
I think it makes more sense given the circumstances and his ability to do probation successfully that he's given this opportunity.
Given the fact that he has the ability to do probation, he should be given this opportunity. I mean, not for nothing. I'm not a completely heartless bastard, although I'm definitely more heartless than a lot of the judges these days seem to be. But I'm not a completely heartless bastard. But, dude, man, we've given you a couple tries at this. And not to mention, of course, all the crimes which we don't know he committed. I mean, it's not like, I think we can all agree that it's not like all he did was the 9 misdemeanors and the 3 felonies and the domestic violences. That's all that's on the record. That's all that's on the record. But I have a sneaking suspicion that he didn't get caught and prosecuted for every single one of the things he's ever done in his life. So those are just the things we know about. Right? So, yeah. We've given you a couple bites at this apple already. We've given you a couple attempts with the probation. We've given you a couple attempts in mental health court. We've given you a couple tries at this, sir. You're not very good at it. Although I'm definitely more a bastard. I'm definitely more a mean judge than a lot of these people. If I had my druthers, more prison time would be coming out sooner. But, still, whatever. This is the society we live in, apparently, now.
I appreciate that, but I think it's time that he gets a taste of something else because.
So, yeah, the judge says, I appreciate that, but I think it's time that he get a taste of something else. And, of course, the defendant, being a good reform defendant, as we've heard so much about, right? And the defendant already saying, I don't think I deserve prison, but, if you have to do it, you have to do it. So the defendant being a good reform defendant who has now had the light finally brought to him, who has now finally seen the light, who has now finally realized the error of his ways, with all these support systems, all these jobs, he's going to accept this cold medicine in the grace in which, it is offered, right? Because justice must be tempered by mercy, but mercy must be tempered by justice. And so he's going to accept this with no problems, right? Right? Okay.
I just can't with that history. In accordance with the laws of the state of Nevada, this court... In accordance with the laws of the state of Nevada, this court...
I believe I can fly. I believe I can touch the sky. Think about it every night and day. Spread my wings and fly away. I believe I can soar. See me running through that open door. I believe I can fly. I believe I can fly. I believe I can fly. Yes, apparently all of who would have thought all of his words were just words and not bearing on reality? Whoever could have predicted that in any way? Whoever could have predicted that he didn't really mean that he was reformed in any way? And he would just say, fuck that bitch, and then try to attack her. I am sensing some context clues, if you will. Some minor, I don't know if you picked up on it. I don't know if you picked up on the context clues. Because maybe you're sharp, maybe your eye is not as sharp as mine because you don't have all the benefit of this trained legal experience that I have. Maybe you didn't pick up on the context clues. That perhaps he's not completely reformed, and perhaps his words are somewhat less than fully correct. Maybe you haven't picked up on the subtle clues that, not all is well. Yeah. He says, "What's the fuck wrong with you?" as he kicks her, as he's being held back. He's still trying to kick her and stuff. The only one who has a problem, sir, is you. And I imagine your sentencing is not going to go very well in the future, if I had to guess. And if you're thinking to yourself, doesn't that mean the judge is biased? No. Because it happened in court, right? There's a difference at law between what we call prejudice and undue prejudice, right? We normally talk of the idea of someone being prejudiced against you. But in strict legal terms, we don't talk about prejudice. In strict legal terms, we talk about undue prejudice, right? So what is undue prejudice? When is prejudice proper and when is it not? Well, prejudice is not proper when it comes from outside the court, right? It comes from outside the confines of the proceeding, right? Things are brought into court by the rules of evidence. For example, the pre-sentencing report that we heard so much about earlier, along with his criminal history, right? Those were brought in, not for the purpose of guilt, mind you, but for the purpose of sentencing, at which they're completely proper, right? We didn't use them to adjudicate his guilt. We used them as part of the sentencing procedure because what he's done in the past is obviously material to sentencing, right? So that's an example of due prejudice, right? It is due to you. The prejudice, or the judgment in this case, is due to you because you've earned it, right? So in the future, as she's probably going to hear this case, I would imagine I would have been the judge and be like, I'm going to nail you to the wall. I was going to give you some minimal time, but I'm going to nail you to the wall and give you contempt and also press charges. It's like, now the judge is really, really biased against me. It's like, no, the judge is not. The judge is not biased against you in a legal sense because the judge is judging based on what you did in court. You are the one by your own actions at this point that are bringing it into court, right? You are the one bringing it before the tribunal. You are offering this wonderful evidence to the court on your own volition. So the court, now using that information that you have so kindly offered to the court as part of its sentencing rationale, is not undue prejudice. It's just you getting wrecked. Personally, I hope he gets the literal max plus probation, or I hope he gets the literal max plus he gets 6 months for contempt, for direct contempt, plus the judge presses charges and we get him more charges for that and tack that all on top. That would be fun and exciting. That would be fun and exciting. I don't know whether I'll get all my wishes, but these are things I want in my life. And also, of course, because it's a judge who is currently sitting as part of a governmental process, not only do you have battery, but you probably have other things like interfering with official court process, interfering with a public official, and so forth and so on. So I imagine there's several different charges that come out of this, right? It probably aggravated battery, if I had to guess, based on the, attack on a public official, attempt to obstruction of justice. Obstruction of justice sounds pretty good. Attempted interference with the judicial process. This is where we get creative and we break out the law books and be like, how many charges can we lay on you for this one thing? Let us count all the ways. He's still trying, by the way. Also, he's committing additional batteries now, by the way. Also, he's committing a battery against a law enforcement officer at this point because he's trying to beat the cop who's trying to stop him. Plus the other people. Those are all batteries. Yeah, that's a lot of additional charges right there. This is like 10 additional charges that have just happened just now. Like in the last 20 seconds of this video, we have 10 additional felonies. Fantastic. He's still...
Hey, get off her. Get off her. Oh, you're good. Stop. Don't do...
Lol. You see everyone there just in the back, kind of camping out. You got just all these people camping back, and one guy's like, "Get off her! Get off her!" Oh, that's the ticket. That's the problem. We didn't ask. That's the problem. We didn't ask to get off her. Lol.
Off her. Oh, you're good.
Also, is that woman in the back? Is that a woman in the back, and is that a sheriff's deputy? Because I think it might be. I can't quite tell. But I don't know. They might be a law enforcement. It's a little bit hard to tell, but they look like they might have the outfit on there in the back. So I'm not sure if that's law enforcement, whether or not they're doing anything.
Stop. Don't do this.
Please.
Hey, where's Mary Kate? Is she okay? Hey.
Resisting arrest, by the way, not that we need to point that out, but, aggravated resisting arrest. How many felonies can we count to? It's a lot. It's a big number. So we're going to max you out on your sentence. We're going to max you out on your sentence because we can. We're going to give you 6 months on top for direct contempt. Plus, we're going to charge you with 10 new exciting felonies.
Wow! Hey, radio somebody? Give me a fucking radio somebody!
Now, we hear this loud noise which occurs. It appears based on context that this guy, who's now emerging from under the desk, reached a panic button. I don't know that, but that seems like the most logical thing, right? So apparently that would be my guess, right? So finally someone thinks to reach the panic button to call for additional law enforcement, right? So we're going to have to deal with this buzzing noise for a while. So, brace your ears and everything.
Oh my gosh, dude. This fucking skin's hanging. No, come on, buddy. Call 911.
The foster mother over here is screaming, "My baby don't do nothing wrong." Lol.
Hey, where's Mary Kate?
She's right here.
But never fear, by the way, never fear about the loud buzzing noise, because Uncivil, being a good streamer, has capped the level of audio that comes your way. I put on a limiter, so no matter how loud it is, it doesn't blow out your ears, because Uncivil is a good streamer. This quality brought to you by Uncivil Law.
Stay down. Get on the ground.
Please, God, please, God, please, God.
Is she talking?
Oh shit! Damn! He's dog.
Can I get a food sergeant? And 3 friends.
Fucking ass. Yeah, help. Get him to where he needs to.
Yeah, go ahead.
Also, his later, what would you call it? Soliloquy? His later soliloquy, where he gave that really interesting soliloquy earlier to the judge in his Hamletian style. Is Hamletian a word? It is now. Where he was giving his soliloquy in the Hamletian style, you know, professing his desire for change. His earlier soliloquy is somewhat not in the same style and meter as his later soliloquies. Like, you know, fuck you, bitch, and his, you know, all the rest of it grunting and all the rest of it, fuck you, and what is your problem, bitch? I noticed a change in tenor. Maybe he's just a really good writer, and he doesn't want to fall into the trap that Shakespeare fell into, like always having his work in the same style or same writing. He wants to be a little bit more expansive, and he wants to try writing in different styles and in different voices. He's just really talented that way. That must be what it is. Was there a jury trial? No, there was a plea of guilty.
Hey.
Osborne!
Hey.
Osborne!
Hey.
Stop! Osborne! Stop! Osborne! Super! Tribal! Osborne! Osborne!
Hey, my man.
I'm also not 100% sure that his later soliloquies are all really words, but to give the devil his due, Shakespeare used a lot of words that weren't really words either. He made them up, and now they're part of the lexicon. Shakespeare invented words, and he was so good at it that the words became part of standard English. So perhaps this poet too, his guttural noises are really a new word that we yet have had to recognize. And perhaps the moving of time will yet reveal the wonders and glory that are his new contributions to the English language. I look forward to learning more about these in updates in the news.
Yeah. Hey, you come here. I'll take care of him. That's my guy. Come around.
That's it.
Huh?
That's it.
You hold him.
Okay. You
That's my guy.
Come around.
That's my guy right there.
Hey, Kelly, is medical coming? Is medical
You guys
coming?
got medical?
And apparently the judge is still on the ground, by the way. Apparently the judge is still on the ground, so she was apparently substantially injured to some degree. Judge is probably going to be irritated next time she sees you in court, I would guess. Like, do you want to recuse yourself? No. If I have to go to court with a broken nose to pronounce sentence, that's what I'm going to do. But apparently the judge is still on the ground, so that's going super duper well.
Yeah, we need medical. Judge, you okay?
It's fucking ass out of here. I got it.
Say, you alright?
Yeah? Hold on.
You're what?
Yeah, you guys call medical?
What is with these people just sitting in the gallery? I don't know, man. They're just sitting in the gallery, just watching the show, I guess. Okay, fine. This guy over here, we got one deputy just kind of standing in the middle, I guess, to make sure, you know, no additional people enter the foray, I suppose, or something. Do you need some popcorn back there or something? Can I help you get something? Maybe a spritzer of some kind?
Yeah, what happened? What happened? He jumped over the bench. What? Are you okay, Judge? Medical's coming.
Come here. Come here.
He's laughing. Come here. He jumped on. Yes. He jumped on his class.
Finally, some female deputies enter the foray. After everything else has been resolved, by the way. After everything else has been contained, now the females enter the picture. Just taking note there, right? So like, okay.
Jen's right here. Right here.
Shane, okay?
Are you okay?
All right,
Yeah, I'm good. Are you all right?
Yeah, I just smashed my head into the wall.
Okay.
She out? Huh? She out or she? No, she's okay.
Sit down, man. Where's this fucking guy?
I don't know if other people in the courtroom are screwed or not, to be honest. Because they can always offer as part of their defense, on the plus side, Your Honor, I won't actually attack you. So I've got more restraint than that. So I don't know if they're screwed or not. It's like, Your Honor, unlike our previous friend over here, I won't attack you in open court. So I deserve a break.
Really throwing punches, but she hit her head on the wall.
Can you help him? Grab the fucking guy and get him over there. I don't want to worry about talking to you.
She said her head hit the wall, so she's feeling a little spacey in her head, maybe a possible concussion or something. There's no way I'm recusing myself as the judge. There is no way I'm recusing myself if I'm the judge and this happens to me. There is no way on this earth I'm recusing myself. We're going to have fun and exciting times together. Oh, yeah.
No. You're bringing him down.
People said she went to the hospital. That might just be precautionary. Or maybe not. I don't know.
Yeah, they're bringing him
Hit her head, bro.
Oh, someone said she didn't go to the hospital, and someone else said she did go to the hospital. So apparently you guys in chat have a dispute amongst yourselves whether she went to the hospital or not.
Hit her head. She hit up hard. Let's bring him around. Huh? Holy You guys want to clear out?
I'm going to get you in the chamber. Let's get you into your chambers. Come with me. Come on. All right. Come on, Judge. Hey, is Sergeant coming?
He's right here.
I got your shoes.
We might need to throw that.
Yeah, we're going to clear these guys out. This fucking court can wait. Hey, let's clear these guys out. Yeah. Everybody stand up.
Let's go.
Clear the fucking court. Everybody, let's go.
Move.
You all right? Yeah.
Is that yours? Is that yours?
No.
Okay, just leave it there.
That's him.
It's going to be a crime scene. So.
Purple Pros in chat says all those men and the lady judge still got. I was commenting on this on Twitter because it amused me, but because someone else made this point. Why were all the men standing around? And I was like, well, because women have been saying they don't need no man, right? Women have been saying that they are strong, independent, and they can help themselves. They don't need no man. So the fact the men didn't come to their rescue is just evidence that the men are listening. Hashtag believe men. And then someone responded to me by saying, basically trying to drag me down and said something like, maybe women should be the bailiffs because the men aren't doing anything. And then they said, you basically in so many words, talking to me, you should go work a field and dig ditches and stuff. And so I responded back to them, don't you mean that women should go dig ditches and in the field? The number of women involved in field work is negligibly low. Women have been discriminated too far against for working in field work. Hashtag equality, that kind of thing. I had fun teasing the left today.
Everyone else out.
Where's Mary?
Everybody out of the hall.
We're locked in.
You sit down. pressure on that. Don't let him remove the
All right, so that brings us to the end of that thing. And my understanding is he's supposed to be back in court today. And if anyone knows what time that's going to be and where it's going to be broadcast, I definitely want a piece of that in my life. So if anyone knows if Delrone Reedon is the guy's name. If anyone knows if Delrone Reedon is going to be back in court today, I definitely want a piece of that in my life. We'll watch the feed ourselves. Anyone know how to find this feed for what's his guy's name again? Delrone Reedon. Anyone know how to find his name, his stream? I'm definitely in for that. Yeah. Yeah, the alarm is supposed to be loud. It's supposed to summon like all the law enforcement because the judge is under attack. But once again, it was better for you than for me. Because I heard it at its original volume, and you guys only heard it at negative 10 decibel because I put a limiter on. Because Uncivil's courteous and doesn't want your ears to be blown out. What happens now to him? Well, we never finished sentencing. So the next thing that would happen is we're going to do sentencing. Because we never finished it. You know, we're going to bring him back into court, and the judge is going to pronounce sentence. I look forward to it. I found it first on Our Nevada Judges YouTube channel. Ooh. Our Nevada Judges. That sounds cool. Ooh.
It's absolutely a big deal. It allows her to continue to be.
Stop talking. They got State versus Roger Hilgus. But nothing about our friend over here, Mr. Reedon. Do we know if the judge is okay? I don't know. We can try to find out. Let's see if we can find out if the judge. I don't know if we can find out, but they didn't mention any serious injury to the judge in any of the other articles, so I'm imagining it's nothing particularly serious. Yeah, the quote apparently was, "Nah, fuck that bitch." Oh, it's New York? Well, someone said New York, but it's not. It's Nevada, right? Yeah, Las Vegas. Someone doesn't. Yeah, they wrote Las Vegas in this article. They wrote Las Vegas in the title and in the photo caption, but in the article they actually wrote New York judge. That's funny. Apparently, the judge sustained minor injuries and there's conditions being monitored. A court martial was hurt but taken to the hospital. So, earlier, the criminal could be seen describing himself as a person who never stops trying to do the right thing no matter how hard it is. He also told the judge, "I'm not a rebellious person." And he also, of course, said, "But if it's appropriate for you, then you have to do what you have to do." The Nevada Attorney General released a statement saying, "Sending our sincerest well wishes to District Court Judge Mary K. Hoffless and the marshal injured. Your dedication, justice, and the court are truly commendable." Let's see if we can find out anything more about her injuries. Everyone's just talking about the attack. No one's really talking about any details about. Apparently, she was not hospitalized. So all the media is saying is that Hoffless, the judge, experienced some injuries but was not hospitalized. The courtroom marshal was taken to the hospital. So there you go. The judge apparently got some sort of minor injuries on her head. So that's what the news reporting is showing. Yeah, no, assaulting officers won't get bonus time in and of itself. That's a whole nother level of charges, right? So it won't get bonus time here, but it will get bonus time in a soon to be coming proceeding, right? So this judge can only adjudicate for the things that she can adjudicate for, right? So this judge has to adjudicate for the attempted battery with aggravated circumstances, right? And she has a whole range of sentencing options. So that's all she can sentence him for. Now, she has the discretion to sentence him presumably to anything within the statutory range. And as we're considering what statutory range would be appropriate, I'd imagine the Court of Appeals will be like, the max sounds good to us, because again, it's not undue, right? It's not undue. It's things the defendant themselves brought into the proceedings by their own volition. They brought it into their own sentencing hearing. The judge, considering what the defendant has to say through his words and deeds, is perfectly valid. So if the judge is somewhat inclined to give him the max, as I'd be somewhat inclined to do at this point, that's fine. She can only give him the max for the offense in which he was found guilty. Of course, she can also issue an additional 6 months for direct contempt, because the contempt occurred in her presence as the judge. So she can award an additional 6 months, unless the statutory range is different, but it's typically 6 months. So I don't know how Nevada does it. I just say 6 months out of habit, because that tends to be the max. The reason it's incidentally the max is because the Supreme Court has said language before that indicates if it's more than 6 months, you might need a jury trial. So we had 6 months max because we don't need a jury trial. So the judge can literally be your accuser and your judge and jury. They can be all those things at the same time. They can be accuser, they can be your judge, and they can be your jury, all rolled up into one. Do you think that's unfair? Maybe don't do direct contempt in front of the judge then, because that's what you're going to get, lol. Right? So she can sentence him to the max and give him 6 months. That's what she can do. Also, I imagine she may be somewhat inclined to be a witness at a future proceeding, along with some other people in the courtroom, at which she will be charged with many, many new exciting things, including battery, obstruction of justice, interfering with a court official, interfering with a public official, assault on a law enforcement officer, battery of a law enforcement officer, and anything else we can dream up when we get creative and we start breaking out the statute books. This is one of those wonderful occasions when the prosecutor hopefully is given the instruction, go open the statute books and have fun. I'd be like, right? That's the film. It's like, go open the statute books and have fun. So I get to get to go through the things and think of every possible thing I can charge them with, because I can. And, so that also, I imagine the judge who, will be a witness at said case and probably offer some testimony in the sentencing phase, if I were to be imagined. I imagine their fellow judge might be somewhat displeased by what occurred to their colleague and might be also somewhat inclined to give them a max for all these new and exciting offenses. So they're going to be in prison for a while if there's any justice in our world. What will be in the transcript? Well, it's on video, so I'm not sure what the transcript will reveal or not, but yeah. Can Nevada judges carry guns in the courtroom? I don't know, but there were a lot of people there with guns, so. Wonder what she was going to give him? Probably not the max. Probably not the max, if I had to guess. She's just like, yeah, I think he needs something different. I'd be surprised if she was going to give him the max. But if she doesn't now, I'll be amazed. So yeah, he probably bought himself, well, let's look it up. What is the max for Nevada attempted aggravated battery? Well, it would just be typically aggravated battery, because usually attempt is the same thing. Let's see if we can look it up. Because they said, they gave a statute number in there, which I don't remember what they looked it up. Damn it. Do I have to go back and watch the tape so we can figure out exactly what statute it was? Hold on. Because he said a number twice, which I'm assuming is a statute reference. So let's go back and see if I can listen to where the prosecutor says it. And what's going on now? Oh no, that's just, there's apparently someone playing it live from yesterday. It's the same hearing. Apparently the judge also was a career prosecutor with more than 27 years of experience. That should go over great.
3697.
That should go over really super duper well.
Entry of judgment. My notes indicate this.
So I'm going to listen to the prosecution again, see if I can get the exact section number he quotes.
Let's see the PSI. I know you see all this, so I don't need to rehash everything. My concerns are
Nah, we can't get attempted murder. We can't get attempted murder. That would be difficult to prove because we'd have to prove the actual intent to kill, and that's a little bit difficult. But we can definitely get our aggravated batteries for days. Yeah, attempted murder would be an overcharge. Keep it simple. Keep it simple. Just give with what you absolutely know for sure, and just, give the things where there's beyond dispute. Don't overcharge. Just give the things where there's beyond dispute and keep it simple would be my recommendation.
Crime of violence.
Yep.
3 PSI, 3 felonies, 1 probation revoked. But I do see on page 5, there are many probation violations, 1 remands.
Attempted essay? No. Again, there's not sufficient evidence for that. Don't get greedy. Don't get greedy. Only stick with what you know you can prove, okay? Just stick with what you can prove, okay? It's easy. He did so many things that are so very illegal. Don't get too creative. Just stick with what is slam dunk certain.
Probation discharge for, but I'm concerned based on the nature of criminal history, home invasions, battery, domestic violence, assault with a deadly weapon in this case that led to an attempt battery substantial. I think felony is appropriate, and I think a prison term would be appropriate.
Is there any restitution or victim impact?
No, Judge, not the man today. So, but I do think prison is appropriate. I asked the court to impose 1948 on this case.
He says 1948. I don't know what that means. We're going to find out together. Okay. Nevada 1948 criminal. Let's see if we can figure it out. This is going to be tough. Criminal code. I don't know what 1948 is. They're just speaking in shorthand. Is it a repeat because I was trying to find... Yes, it was a repeat because I was trying to hear what section they quoted. To see if it was like a criminal section. This is like, I think 1948 is appropriate. It's obviously a citation to some statute that they know about that I don't. Yeah, Nevada revised codes. Yeah, let's give Nevada revised code 1948 a shot and see if we get anywhere. NRS. Okay, Nevada 1948. Is it a battery thing? No. You gotta hate that when they say something and you don't know quite what they mean. 1948 is a sentencing guideline. That sounds good. That sounds promising. Let's see. Sentencing guidelines. Felony guidelines. Let's see. Well, Kurt doesn't know everything about every locality's law. That would be a little bit much. I don't know everything about every state's statutes and exactly what citations there are. That'd be a little bit much. For that matter, I don't know everything about every statute in the states in which I'm barred. That would also be ridiculous. Yeah, it's like, yeah, I don't know things sometimes. Yeah. Code specifically for court mental health. Well, I'm going back to my previous attempt of just figuring out what the crime is, and look like he picked up battery on a protected person. $1948. I'm not seeing it. Yeah, I'm not seeing it. Let me try putting the whole thing in quote marks, see if that matters. All right, let's see if this article gives me more details. No, that was in the past with respect to that. I don't think it's respected now. Yeah, I don't know. Yeah, we're beyond this. Nevada is a misdemeanor for battery on a protected person. What's protected person is a special castle now. We discussed that, Azeroth, earlier. Pay attention. All right, I'm giving up. So the charge. What was the charge exactly? So I can listen to exactly what this is.
Cause or reason why judgment should not be pronounced against you at this time?
No, Judge.
By virtue of your plea of guilty, I hereby judge you guilty of attempt battery with substantial bodily harm.
Okay. Attempted battery with substantial bodily harm. Let's see this. NRS attempted battery substantial bodily harm. Okay. All right. Substantial bodily harm to the victim or battery is committed by strangulation for a category B felony, imprisonment in state prison for a minimum term of not less than 2 years and a maximum term of not more than 15, and may be further punished by a fine of not more than 10,000. Or is it NRS? Yeah, NRS 200.481. Is this one I want? Okay. I don't know if there's substantial bodily harm beyond that. This is the only reference I see in the Nevada Code. If the battery is committed by a probationer, a prisoner who's in lawful custody, or confinement on parolee with the use of a deadly weapon, and substantially bodily harm results, or battery is committed by strangulation, for category B, 2 to 15. That looks right. That's NRS 200.481. That looks right. That looks right. So NRS Nevada Revised Code 200.481. We already heard about it as being on probation many times before, right? So yeah, we have all these wonderful definitions. And then we just skip right down to the bottom here. Right. So we have, if battery is committed by a probationer, a prisoner who's lawful custody with use of deadly weapon and no substantial bodily harm, or substantial bodily harm, 2 to 15. That looks right. Yeah, because we have, and even if we're up here, it's the same thing, right? So if battery is committed with the use of a deadly weapon, substantial bodily harm, 2 to 15. So that's what, yeah. So I doubt she was going to get 15, give 15, but I bet she does now. I bet you she does now. Right? I doubt she was going to go to 15, but I bet you she does now. So he probably earned himself an additional 12 years in prison. If I had to guess. Again, it's just a straight guess. I don't know, but it's just a straight guess. But yeah, I think he earned himself another, let's say another decade. He earned himself another decade in prison just now, plus all the new and exciting felonies we get to charge him with, which will probably be another 20 years on top of that. So yeah, he's going to jail for a hot minute. He was there for sentencing on a probation violation? That's not what I heard. That's not what the judge said. The judge said, I adjudicate you guilty on attempted battery with that. That's not what the judge said. It was a new charge. It wasn't a probation violation. It might also be a probation violation. But that doesn't seem to be what it is. Like, I'm sure it's a probation. So also we can sentence him to the additional probation he was on. So we're going to give him 15 years plus whatever else he had for all the probation that he's already on. So we'll give him 15 years plus revoke all his probation, find him guilty of all the probation violations, and give him all those years. So, yeah, he's going to be in jail for a while. He had 2 priors. He had 3 felony priors and 9 prior misdemeanors, plus a score of domestic violence offenses. He did not have 2. He had a lot. He's in jail now. He's in jail now, I guarantee you. I think the attempted part of battery with substantial bodily harm is legal fiction. It's not at all legal fiction. It's not at all legal fiction. Attempt is when, essentially, to boil it down, attempt is when you take, with intent, to take a substantial step. Well, no, that's conspiracy. No, substantial step is about right for assault or any other crime, right? So there is a bit of a tricky line when it comes to attempt, as between mere preparation and the actual offense. So how far back do you go is a bit of a legal question. So, for example, like, you know, if I don't know what the scenario would be, but if you could prove it, like suppose some people rob into the bank. Suppose you could prove it. People walk into a bank with the desire to rob the bank. You know, they have their guns and everything on them. But unbeknownst to them, you know, when they walk in, they find that there's 15 police officers who just happen to be in line because, you know, it's payday or whatever. So they decide to walk out and not do the bank robbery. That would be attempted bank robbery, right? Because we're well past the preparation stage. We have now made a substantial step towards the offense. An attempt is typically charged the exact same as the offense. So, like, yeah. So how far back in time you go becomes a bit of a question. So if they walk in the door, you know, with all that, then they're obviously guilty of attempt. Okay, how about as they're walking up to the door? How about as they're driving over there? How about as they're, you know, driving, you know, and so forth and so on. How far back can you go becomes a bit tricky, but it's not a legal fiction. Attempt is absolutely a thing. People do it all the time. Like attempted fraud, right? I tried to defraud you, but you picked up on it, right? That might be arguably what was happening, for example, for Donald Trump, for example, if you believe that, right? Donald Trump was giving bad numbers. Maybe the people picked up on it and they weren't deceived. So that makes it attempted fraud rather than fraud. Yeah, attempted's not a legal fiction. Was it a but-for of a victim dodging a blow? Can't speak to that. I can't speak to that. Maybe he was pounding on the door, you know, with a gun in hand. You know, maybe he was trying to beat down the door of somebody, and he had a gun or a weapon in hand. And that was it. I don't know. Well, once they enter the bank, for sure, Mark. That's the point. Once they enter the bar, but that was my question, right? There's no answer to the question, Mark. That was the point of me asking, right? If I knew the answer, I'd just tell you, right? There's no answer to the question, right? How far back in time you go is the question. There's no answer to the question. So, of course, once they walk into the bank, it's attempt. The question is, where does the attempt start? Does it start only at the time they walk into the bank? Probably not. How far back in time can you go? I don't know. That's the whole point of the question, Mark. I think you missed the point. Sorry, I was just guessing. That's okay. That's okay. I wasn't mad. I wasn't mad. I wasn't berating you. We were having fun. I was correcting you in a friendly, jovial spirit. I hope you took it in the light in which it was offered. I wasn't yelling at you. I wasn't being mean about it. I was just like, you know, that was the point of the question. You're fine. We love you. Who will decide his charges now? The judge who was just attacked will. I hope. And she has every right to. As to the new and exciting charges, not her. She'd be a necessary witness. But as to the things that he's pleading guilty for or pled guilty for, she can remain judge. No problem. Lol. Yeah, Kurt's just being a little snarky. It's what I do. Everything is attempt until conviction. Well, I don't know about that, but he was convicted. It was the first thing that happened. It's like where the judge literally said, I find you guilty of that. That was the conviction. Moving on to sentencing, right? How can she pass judgment? We've discussed that. We've discussed it, but we can discuss it again. That's fine. No problem. How can she pass judgment on it? Because it's not undue prejudice. That's how, right? It's not undue prejudice. A judge is not to be biased by things that exist outside the court proceedings. That's the thing, right? So the pre-sentencing report, for example, that came in, and his criminal record that came in after as part of the sentencing phase comes in through the rules of evidence. It's part of their, because he apparently pled guilty to whatever it was. So he apparently pled guilty to whatever it was. So the rules of evidence are such that, you know, well, now we bring in the pre-sentencing evidence. Now we bring in his criminal history because we're not trying to adjudicate guilt or not at this point, because he just pled guilty, because that was the first thing that happened. We adjudicated him guilty. Moving on to the sentencing phase, now we bring in this new exciting evidence, right? So the judge is not biased because the judge is basing things based on what is being brought in through the evidentiary record or the court proceedings, as the case may be. So the judge can continue to sit judgment because it is the defendant themselves who, through their voluntary acts inside court before the judge, brought new information to the judge's light that she would be well empowered to consider. She is not doing anything other than taking note of the evidence the defendant himself, by his own acts, has now offered. So the judge said, oh, I was going to sentence you to this, and now I'm going to sentence you to this much more exciting longer term. Because you, the defendant, have convinced me through your plea of, I believe the plea was exactly, what was the plea again? Because we had it exactly verbatim. What was the exact plea that he gave? Where was the thing? Hold on, I have to find it. What was the exact language? Okay, hold on. What'd she say? He said something like, fuck you, bitch. What was it he said? Exactly. We can watch it. We can watch it again. We'll just, why ask these questions when we can just go back to the original? So let's watch the defendant make his renewed plea, right? He gave his earlier statement earlier to the judge about what he wants, and the judge is about to sentence him, and he'd like to ask for reconsideration. He'd like to ask for reconsideration. So let us observe his motion for reconsideration as it takes place.
I appreciate that, but I think it's time that he gets a taste of something else, because I just can't with that history. In accordance with the laws of the state of Nevada, this court...
So fuck that bitch was his motion for reconsideration that he himself made through his action. And the judge is like, you know what? I think I'd like to reconsider my earlier decision to sentence you to less. I have new and exciting evidence that you yourself have brought in before the proceeding that I can use against you. That is not prejudice, or at least it's not undue. It's not undue prejudice. It is prejudice that is due to you because of you making it so. So she can continue to serve as the judge, no problem, and the Court of Appeals will laugh in his face. What did I tell you rule number 1 of litigation was? What have I told you time and time again? Rule number 1 of litigation is, don't piss off the judge. Yeah. 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 So yeah. Motion to reconsider granted. Exactly. Yeah. Motion to reconsider granted. Exactly. Yeah. Don't piss off the judge. Yeah. Supreme Court of Nevada is meeting to change a rule to allow concealed carry behind the bench. Okay. Fine. Yeah. So having disregarded rule number 1 of litigation in a somewhat dramatic fashion, the judge taking note of said dramatic fashion is prejudice that is now due to you. Congratulations. I hope you enjoy Senate. I hope you enjoy prison. That's not fair, Court of Appeals. She was biased against me. Why was she biased against you? Because I attacked her in open court. Sentence confirmed. Oh. Supreme Court of Nevada, that's not fair. Lol, get wrecked. This is the FO part around. This is the FO part around. He fucked around, and he's gonna find out. He fucked around, and he found out. Also, it's not the first time fucking around. So, yeah. I am in a very good mood today. I'm in an extremely good mood today. So I will absolutely take a day when I'm in a good mood. I had some green juice. It was very nice. I'm thinking about getting some green juice mail order so that I have some like every day to help, with the phytonutrients and stuff. Could be good. Yeah. Yeah. She might have a conflict. She has no conflict. She's fine. She's fine. She has no conflict. Actually, I got the juice from Juice Land. But I was thinking about getting some sort of mail order juice because there's a couple companies that do mail order juice at a reasonably good cost. You can get like 30 bottles for $200 of cold pressed juice. Might do it that way. I don't know. I haven't decided. I'm still looking for vendors. Isn't there a charge for interfering with an official court proceeding? Yes, there are. There are all kinds of new and exciting charges coming his way at a later time. She has no conflict. She has no conflict. She's good. She has no conflict. She is good. I was looking into soju, I think it was called, and what was the other one? There was like soju was one, and uh uh pure maybe, and who else? There are a couple companies that do it. Raw Generation. Yeah, Raw Generation, Soju, and Pure were the ones that came to my earlier searching. I'm licensed in Texas and Virginia, Crisis Cat, and I'm licensed in Texas, Virginia, and before the United States Supreme Court. Can I explain what Twitch is? Twitch is primarily a live streaming platform for gamers, traditionally. That's where people who play video games typically stream. YouTube has not typically been used for that purpose. But of course, it's not used exclusively for that purpose. And now that Twitch allows dual streaming, which they didn't used to allow, I see no particular reason not to stream in both places. Plus, on a financial level, for everyone who has Amazon Prime, they can subscribe to me on Twitch, which is the paid option, for free. So you can give me money without actually you yourself having to give me money. Jeff Bezos gives me money. So that's the nice thing, right? So first of all, it helps expand my audience, because why not? Second of all, for everyone who has Amazon Prime, you can just give me free money. It doesn't cost you anything, but you support the channel. How nice. Twitch is in fact a successor to Justin TV. Anyone who's been around that long. That's a long time ago, man. That is a long time ago. TOS is worse on Twitch. I'm not sure that's true. I think I tend to disagree. I think the TOS is better on Twitch, but, you know, different people can disagree. I can't speak, Eddie, to the relative safety of any particular platform when it comes to minors. That would have to be a decision made by the adult in the case. I'm not going to make any representations as to whether YouTube, Twitch, or any other service is safe for teens or not. Over under and being wheeled into a hearing. He'll definitely be in shackles. I promise you that much. He'll definitely be in shackles. Yeah, I'm not making parenting decisions for you or anyone else. I am not making any representations as to whether or not any social media is suitable for any child. That is not my decision to make. That is the parent's decision to make. I'm not even representing that YouTube is a safe medium for children. That's up to a parent to make for themselves. This stream is not labeled for children. The stream is not labeled for children, so I am under no particular obligation to say that the stream is safe for children. I do not make that representation. Do I do lives on Twitch? I'm co-streaming. We're live on Twitch as we speak. How do you link Twitch to Amazon Prime? Good question. The bot will tell you. What can they do to protect judges in the courtroom? Well, they could put another officer in between. You sent me gifts? Oh, thank you. Is the bot not working today? Is the bot having a day off? Lame. We're glad to see that you're doing better, Sandy, by the way. Yeah, let me do all the gift things you did today. All right, Matt Bond gave me $2 Australian, says for boots and chaps to go with your cowboy hat. Time Lady became a non-civilian for 99 cents. Matt Bond gave $5 Australian to say Spider Crime. Spider Crime does whatever Spider Crime does. Brenda Morris has been a member for 14 months. Thank you very much. Nikki Crowns gifted $2. Apparently their first super chat ever, says his name is Deborah. I'd be angry too. His name is DeLone. His name is DeLone Reedon. DeLoneReddden. His name is DeLone. At least that's what the news is reporting it. DS has been a member for 15 months. KL Burke has been a member for 9 months. Thank you for hitting the join button. Lynn Barry has gifted 10 gift memberships. DS gifted 10 gift memberships. Sandra Oliver gifted 1 gift membership. Sandy, our longtime mod and fantastic person, has been a member for 15 months. And Goo Eye gifted 20 gift memberships. Thank you very much. All right, I'm gonna. His middle name is Deborah. That's funny. His middle name is DeLone. Is his first name really Deborah? That's hardcore, man. Am I a First Amendment absolutist or close to it? I'd say relatively yes. There are some caveats on that. The first and foremost of my First Amendment position is what is appropriate for adults is not necessarily appropriate for children. I think children have a First Amendment right to speak, and I think they have a First Amendment right to have their voices heard. But I don't think that children necessarily have a First Amendment right to consume all media that an adult would be able to consume. We take lines of delineation in our society for very good prudential reasons. So what is appropriate for an adult is not necessarily appropriate for a child. I think is pretty unlimited. We'll get to the classroom in a second, but outside the classroom, I think their ability to speak speech is pretty unlimited. Their ability to receive speech is limited because of the nature of them being young. When it comes to them being in school, I think their speech is limited in the same way it would be limited for an adult in a similar context, which is to say, the government function must be allowed to function. It's basically essentially a time, place, manner restriction. So in the same way that, you can't just go into a DMV for the hell of it and just, hold a parade or a protest or, have a picnic lunch in the middle of the DMV, the nature of those restrictions would be parallel to school, because the nature of the restrictions come out from the ability of the governmental function to function. It's a time, place, manner restriction because we need the government function to be able to actually work. And as the government has its many problems with functioning already, we don't need to add to them. So the restrictions on speech within school, I think, are appropriate because we need the school to be able to school. As to adults, the classic things that are not speech in a First Amendment sense, I don't tend to think of them as exceptions to the First Amendment. I tend to think of them as not speech at all. The reason I say that is because the First Amendment talks about the freedom of speech, and we have to understand what the freedom of speech is, right? The is a definite article. It's referring to a specific thing. It would be akin to me saying the piece of land, right? If I say your right to the piece of land shall not be infringed, we can't even talk about what infringement might mean before we can talk about what the land is, right? It doesn't make any sense. We can't even talk about what infringement might be without defining the boundaries of the land. In the same way, when it comes to the Second Amendment, as I've talked about a lot, and when it comes to the First Amendment as well, we first have to define the boundaries of what the freedom of speech is. So certain things like, for example, defamation are not within the freedom of speech. I don't think of them as exceptions. I think of them as not within the boundaries at all. It'd be like saying that piece of land is not within your borders. It's land, surely it is. It's land, surely it is, but it's not within your borders. Is it speech? I guess, but it's not part of the freedom of speech. It's not within the borders of the thing. So that's how I sort of think about it. Yeah, that basically is the long and short way about how I view both the First Amendment and Second Amendment. I think, for example, people in the Second Amendment, how to talk about shall not be infringed, are a little ridiculous, because before you can even talk about shall not be infringed, you have to first talk about what the right to keep and bear arms means. You have to talk about what the right is. And whatever the right is, it certainly is not the right to have any arm, anytime, anywhere, for any purpose, any more than your right to the land is all land forever. That's ridiculous. So you have to first define the boundaries of the thing. Thank you for coming to my TED Talk. Check Twitter? Sure. And then, of course, once you define the boundaries of the thing, you're still not done, of course. You're still not done. Because once you define the boundaries of the thing, you still have to talk about what infringement might mean. What does that mean? What does it mean to infringe your land? What does that mean? Right? For example, what does it mean that your land shall not be infringed? What exactly does that mean? So you then have to go have that discussion, but you have to do the boundaries thing first. What does Congress shall make no law? Abridging, right? Abridging being the magical word, I suppose, for the purposes of the First Amendment. What does abridging mean? What is an abridgment? The Second Amendment talks about infringement. What is an abridgment? What is an infringement? Are those the same thing? Are they different things? What does that mean? What does it mean to abridge? What does it mean to infringe? What does that mean? And then to answer that question as to the First Amendment, you can go look at shelves and shelves and shelves forever, as I've sort of done, because I like the First Amendment. And Second Amendment analysis will fit comfortably into a small book at this point because it needs love. There's chatter something was filled in Sarasota? Yeah, it wouldn't surprise me. So the boundaries were set in the Federalist Papers. I wouldn't say the boundaries were set in the Federalist Papers and Anti-Federalist Papers. I wouldn't quite agree with that. I would agree that the Federalist Papers and Anti-Federalist Papers are very good indicia of what the right had to mean, but I don't think it was the end-all be-all. The reason I say that, by the way, is the exact same reason I'd say that for a piece of legislation today. Because I don't on a fundamental level interpret the Constitution differently than a statute. I think about them in the same way. The Constitution has supremacy over a statute. The Constitution's more important than a statute. Statutes must bend to the Constitution, but the way I go about interpreting them is fundamentally the same. So the issue of how I prioritize the two is not linked to how I interpret the two. So if you gave me a statute today, any statute from any time period for that matter, and you said, okay, the author of the legislation said this, or some committee said this, or someone on a floor speech said that, I would say that is of relatively marginal utility, because Congress, for example, can only pass legislation by Congress passing legislation. So what the author of the bill thought, or what the sponsor of the bill thought, or what a committee of the bill thought, or what even one house even if somehow the entire House, as opposed to the Senate, said, well, this is what we think, the House can't act alone, right? Only Congress can act. So these writings or thoughts are of some limited utility when it comes to it. So I think the Federalist and Anti-Federalist Papers are certainly, I think the Federalist and Anti-Federalist Papers are of a higher station in some ways, because they were being written at a time when the Constitution and Bill of Rights was being considered. So these were things that were circulating among the people as the polis, right? As the population was considering whether to adopt the Constitution and the Bill of Rights. So it was outside the confines of Congress and was being published in a broad way and was being considered by the states as part of their ratification efforts. So as a result of the nature of how that publication was published and how it was circulated and how it was considered by the legislatures, it has an enhanced station compared to like a floor speech on the House. But still, I don't think it's the end-all be-all, if that makes sense. And someone said they sent something on Twitter, and I'm trying to figure out where that is. Someone sent me something on Twitter. I'm confused. No. Okay, great. What else? Statutes apply to commerce inferring a contract? No, they don't. Statutes apply to the powers of Congress as delineated in the Constitution. Please see Article 1, Section 8 for more details. Congress also does regulate commerce. That's true. That's part of their powers in Article 1, Section 8, but they have powers beyond that. Text, history, and tradition is the right way to interpret the Second Amendment? Fundamentally, yes. I would look first, of course, to the text. In the case of the Second Amendment, I don't have a lot of words to work with, so it's not that much help, but, you know. But I would look, I think the Supreme Court has it about right about now. I think that the writings and particularly judicial decisions, I think, that are more contemporaneous with the passage of the article, as the case may be. So obviously what time period you're talking about is going to differ from the First Amendment to the 14th Amendment, for example. But I think that the text, of course, is paramount, and then the history, particularly as it relates to judicial proceedings, particularly in the run-up to the adoption, would be informative. Would be more informative. As you get further back in time, I think they're less informative, because presumably the people at the time were considering things that were contemporaneous, but it isn't to say they weren't considering older things, because, you know, people in the past used to like actually care about shit. So I think more contemporaneous things relative to the adoption of the article in question are going to be more relevant. It's also going to depend, of course, on the nature of how they were circulated and what sort of penetration they had among the public debate. So that's the right way to think about it, right? You want to, you know, and to some degree, you can of course call on all of English common law, which started in 1189. So you can go back all the way to 1189 if you need to, because that's the date that law started, 1189. So you can go back as far as that if you need to. The mod chat. Okay, let me check mod chat. Oh dear. Oh dear. This injury is more severe than let on. Oh dear. This is somewhat graphic. For the deputy. And this says the judge was taken to the hospital. So apparently there's a dispute about whether or not the judge went to the hospital or not. So we'll let that go by, because this one says it was. But I'll put this up on screen because you know, content warning. It is a little bit disturbing. How did it start in 1189? Well, the British government, such as it was, well, no, actually, that was later in time. I forget when they established it. But at some point, it wasn't 1189 when they did it. It was sometime later. But at some point in time, the British legislature actually passed a law that said, you've ever heard the phrase time immemorial? You ever heard the phrase time immemorial? Ever since time immemorial? It's like, do you want to know what time immemorial is? Legally, it's 1189. Illegally, it's 1189. The British legislature at some point passed a law that says legal history and time starts at 1189. It's 1189 because the British said so at one point, well before we were a country. So that's why, because that's when law started, 1189, because the legislature of Britain said it did. How exciting. No, not Magna Carta. Not Magna Carta. Or was it 1289? Hold on. Hold on. Yeah, 1189. Yeah, 1189. Yeah. Period way back in time when there's no recollection or record. In the UK, a statute of the year 1275 said that before the time of King Richard I's reign, or 1189, was to be declared to be time immemorial, also known as time out of nine. So in 1275, the British legislature passed a law that said time started at 1189, and that's where we are. Great. The more you know. The more you know. It's just the law, man. It's just the law. All right. All right. Content warning, cellophane warning, all the rest of it. We're going to put pictures of the deputy's injury on screen. It is fairly severe. So you've been warned sufficiently. Yeah, here it is with the deputy. That's a pretty serious gash in the head. Yeah, that's a pretty serious gash in the head. That's going to need some serious stitches. Yeah, so I don't think things are going to go well for our miscreant friend over here with respect to his sentencing or his future exciting crimes, which are to happen. Yeah. So that's pretty serious. Maybe it's a sharp edge. I don't know. I don't know if there's a sharp edge or not. I don't know. But if you used a weapon, I mean, yeah, I mean your thought isn't invalid. I mean, it does look a little bit more clean than you'd expect from just bludgeoning. So, although to be fair, this is some sort of this is some sort of shot in the hospital, right? Obviously, I mean, because there's no blood around him. So we don't know to the extent before this shot occurred what his damage like was. So I don't know if he had any sort of, initial surgery or anything when this shot was taken. So this may or may not be reflective of the injury he necessarily received at the scene. But if the suspect used or the criminal in this case used, because we saw how it happened, if he used a knife or something or other weapon, he's going to have a really, really bad time. He's going to have an extremely bad time. Yeah. No, he's going to go to jail for a long time. He's going to be in prison for a long time. If I were the judge, I'd have absolutely no problem maxing this guy out on the 15 years. I'd have no problem maxing him out on 15 years. Come after me, Court of Appeals. Seriously? Come after me, Court of Appeals. Why did you sentence him to 15 years? Well, he physically attacked me by leaping over the table and then leaping over the bench to physically attack me. And he seriously injured the deputy. Here's a picture. Oh, okay. Right? So, yeah, 15 years. Come after me, Court of Appeals. Come after me, Court of Appeals. Yeah. And then we're going to have new and exciting charges against him. So he's going to be in prison for a hot minute. Yeah. Why did you ever sentence him to so much time? Your Honors, we'd like to play a video. Yeah, I know we only have 15 minutes of oral argument, but I'd like to use 5 of those to just play a video, if that's cool with you. I don't know if you can do that in the Court of Appeals land, but I'd think about it. "15 years isn't long enough. Maybe you're not understanding me. Maybe you're not understanding me. The judge can only sentence him for the thing that he was brought to trial for. Right? The judge said, I pronounce you guilty of attempted battery with grievous bodily whatever it was that she said, because I have already forgotten the vernacular. That particular crime has a sentence of up to 2 to 15 years. The judge doesn't have any power to sentence him to anything other than the charge of what she's been found guilty. The judge, having had new and exciting evidence brought by the defendant, would be somewhat inclined, I'd imagine, to issue the max, which is 15 years. But that is relation to the crime on which he's already pled guilty. That has nothing to do with the new and exciting charges which are coming his way for obstruction of justice, attacking a police officer, attacking a judge, obstruction of justice, and everything else we can dream up. So, yeah. Also, I don't know the power, I don't necessarily the degree to which the judge can do it, but the judge would also presumably, I'm going to presume, have the power to revoke all of his existing probations and add on whatever time he already has. Well, strictly speaking, it wouldn't be adding time. He'd just be serving the time he already has. So he would serve the time for whatever probations he already has. Plus, of course, an additional 6 months, because she can also sentence him for direct contempt, which occurred in her presence, unilaterally. Right? She's the complainant, jury, and judge, all rolled up into one. So she can bring the charge, try the charge, and sentence for the charge, all rolled up into one. Don't piss off the judge. So she'll give him an additional 6 months for that. So that's where we're sitting. Yeah, contempt of court. That's direct contempt, 6 months. We could charge him with criminal contempt, I suppose. But I just do the 6 months and call it a day. But, you know, different people for different styles. What does Nevada have for upward departure options? I think the judge can do anything. I imagine, yeah, the judge can do anything at the end of the day, right? There's all these guidelines that exist, but I don't know of any state anymore in which the guidelines are mandatory. So the statute says 2 to 15 years. So, and if the judge says 15 years and you need a reason for upward departure, point generally in the direction of everything. It's not hard, right? What is your basis? You know, just what is your basis for the upward departure? Just put this photograph in your order. You know, what's your base for upward departure? This is my basis. Oh, okay. You know what I mean? Is attacking a judge a higher charge than an LEO? I don't know. I'd have to look it up. I honestly don't know the answer to the question. Would that not be practicing law from the bench? No. No, it's not practicing law. No. It's being a judge. There's nothing in that that's the practice of law. The practice of law relates to, you know, me representing someone in court. That's the practice of law. Or not court, for that matter, because I was a transactional lawyer. I didn't go to court. So that's the practice of law when you represent somebody. She's not representing anyone. That's not the practice of law. No, she's not practicing law. She's just being a judge. She is the accuser. She is the accuser, the jury, the judge. She's everything rolled up into one. That's not practicing law. That's just I'm the judge. You know how they say tell it to the judge? You just did. You know how they say tell it to the judge? This is apparently what you wanted to tell the judge. No problem. Federal prison, nothing obvious, no immediate obvious federal charges. Although state prison tends to be worse on the whole. So if your idea is that that federal time is better, the general consensus is that federal time tends to be a little bit better. I mean, it's not much, but it tends to be better. So if you had to pick, right? He refused to leave his cell today. I would drag him out of a cell personally. I'd drag him out. I'd be like, no, he's coming to court. We're going to drag his ass out here. I have no problem with that. Marilyn C says, assuming that. I don't know what you think I'm assuming. Or not. But thank you for the super chat. What do you think I'm assuming? She's representing the victim? No. 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 She's the complainant. Also, the victim in a criminal proceeding isn't represented. That's not how that works. Victims don't get to be represented, not least in a formal sense. She's not representing the victim. No. Also, she's strictly speaking not representing. She is the victim. But, you know, never mind. It happened in court. I assure you, I know the law. It's fine. No problem. Don't piss off the judge. It suggests he's mentally ill? No, not at all. I don't see mental illness anywhere. His inability to control rage is not a mental illness. He was quite lucid. He was quite lucid during an earlier soliloquy. I don't think he's mentally ill, not in a legal sense. I have no problem with this. No mental issues. I see no problem. Would anyone sane do this? Apparently, yes. Angie Torres, you don't confuse anger with insanity. You have to control your temper. No, he's not insane. He's an idiot. Angie Torres gifted 10 gift memberships. Thank you. So if it happens in the presence of the court, it's admissible? Pretty much, yeah. You're the one offering it. Yes, you have offered it. Yeah. I mean, yes. Yeah. Kinda. Yeah. I mean, that's what direct contempt is. That's what direct contempt is. Direct contempt is literally when you do bad shit in front of the judge. That's what direct contempt is. So yeah, that's very admissible. It's also very admissible for the purposes of sentencing, because the judge is the finder of fact. Right? It's a fact with respect to sentencing. No problem. Don't piss off the judge. Girl with the Animals gives them judges are basically demigods. Judges are minor demigods. The sooner that you recognize that, the happier you will be. Don't piss off the judge. Kintari gives 99 cents or becomes an uncivilian for 99 cents. And Catherine Frazier has been a member for 14 months. Am I a bar member? I am licensed to practice in Texas, Virginia, and before the United States Supreme Court. I'm licensed to practice. There, by the way, on my shelf. That's literally on my shelf, literally my Supreme Court license. I know you normally think of a license as something that goes in your wallet, but the Supreme Court doesn't play that way. They don't give you a wallet license. They give you a big ass license. That's literally my license for the Supreme Court in the background. So, yeah. When have I argued? I've never argued before the Supreme Court. I've never argued before the Supreme Court, but it would be an honor of a lifetime. As I'm sure you well know, the Supreme Court is a court of limited jurisdiction. They only hear about, and they've been hearing less cases these recent years, but they only hear about 80 to 120 cases every year. And a lot of those cases come as a result of appeals from the states, in which case you're going to have the Solicitor General of the state representing them. Also, same for the federal government, the Solicitor General of the United States will represent them. And as also a result of the fact that it's fairly rare, the Supreme Court tends to be dominated by repeat players because they have a proven track record, although you do certainly have first-timers there too. It's a tough gig to get, but it certainly would be an honor someday. Do I have any pet issues? I do have this theory that marijuana regulation is invalid under the 18th Amendment. So I do have this semi crazy idea that I'd like to try. The Supreme Court would probably laugh in my face, but it would be fun to try. It would, of course, mean, if I'm right, it would mean basically the end of all drug regulation by the federal government. And, yeah, so it would be a pretty, yeah. Okay, moving on. Well, I don't know about all, but it would take a big hit. Let's hear it. I've discussed it before. I don't want to get into it right now. Is it on parchment? No, I don't think so. As far as I can tell, it's on very nice paper, like diploma paper. Ireland legalized all drugs for 24 hours. I heard about that when it happened. That was funny. I really don't think it's a mental issue, Jimonian. I really don't think it's a mental issue. I just think he has serious anger control problems. I think he's an abusive asshole. I don't think he has mental problems. I don't think he's mentally unwell. I think he's an abusive asshole. And I think he deserves to go to jail, probably forever at this point. Breaking rank? Never heard about that one. Yeah, we do have an interview tonight. We'll redirect you over that way. We do have an internet view with Juror 1 in about 4 hours. That's going to be fun. All right, I'm going to go ahead and sign off for now because I think we've been answering questions for a while, and we long since probably passed the point where we need to land the plane, but I've been having a lot of fun. I'm Uncivil Law, and until later, my friends, I hope all is well. Cheers, my friends, and goodbye.